No, it is normal. Not under 156. Normal complaint, then FIR.
Yes.
Remember, the allegation is that, my lord, under the leadership of one Gaurikanta Mukherjee and others, the accused persons armed with shovel, iron rod, sickle, etc. They attacked the house of the complainant. They ransacked the house, looted away the property, bought about 3 lakhs, set fire to the tile shed roof of the building, damaged the toilet, assaulted the complainant and the brother and sister, and then they put them in fear of death and reverse hardship. However, my lord, with the intervention of the villagers, my lord, they managed to escape from the place. Now, my lord, this is the allegation. Now, my lord, charge sheet was submitted against 28 persons. 2 persons, my lord, were not charge sheet. Now, in the charge sheet, my lord, the reverse section, section 436, was deleted.
36 deleted.
Yes, 436 was deleted. Though, my lord, the ingredients of 436 appear from the charge sheet itself. Now, your lordship kindly comes to the charge sheet at page 18.
Page
18, 1
Yes.
It starts from page 18, my lord. Lordship will find 28 persons have been charge sheeted.
What is the seizure list?
My lord,
What is the seizure list? Is the case under section 436? What is the seizure list?
That is the question.
Is there any seizure list?
No.
the
No, my
seizure list is not there.
Why?
And that, my lord,
How could it be proved 436?
my lord, that is why, my lord, 436 has been deleted.
Huh.
But though there are elements of 436, kindly comes to page 21.
21.
21 at the top, my lord.
Yes, yes.
Kartik Mitra, Sujata Mitra, Shanti Mitra assembled and entered unlawful assembly being armed with deadly weapons, lathi, rod, bhojani, etc. and attacked the complainant and the sister in the house of the complainant and abused his language use, as well as they entered into the plot number 627 of Orampur Haldar Bagan under Chinsura PS and set fire into the room made of tali roof and dorma bar, and thereafter threatened them with dire consequences, damage value about 3 lakhs, and the accused person used rough language, etc. So, my lord, this allegation has been admitted in the charge sheet.
Sir, it is not admission. It is a brief facts. Facts of the case.
During investigation, it is found, my lord.
Where it is written during investigation, it is found. Where it is written, brief facts. Start.
My lord, it is a brief.
Brief facts. Investigation, it is found, but 436 was not done. What is the seizure list, sir? Burned tiles?
My lord, seizure list is not there, my lord.
How could it be proved 436?
No, I am not on that, my lord. I have not come up from quashing of the charge sheet.
Then
But I thereafter filed an application.
you are on behalf of the de facto complainant.
My lord, I thereafter filed application, that is filed application for change of the additional public prosecutor who is not listening to the de facto complainant and not placing the relevant document which the de facto complainant wants to project before the court. Now, my lord, those applications are also annexed in the application. Now, my lord, those applications were turned down. They were rejected on the ground.
Sir, this is not the domain of the court to change. It is an administrative order.
Yes, but
How could you make any prayer for change of PP before the court?
no, what? Kindly comes to
PP is appointed through administrative order.
I understand, my lord, but PP can be, lordship kindly comes to the application, my lord.
So where is the application?
Page 25. There are many applications. It starts from page 25.
Sir, which order you have sent, sir? I am not on all your
Kindly comes to the last
last
page. My lord.
page.
Yes. That is a certified copy.
Certified copy. Yes.
Yes.
Certified copy.
My Another time
This day
is-
fixed for hearing petition application filed by the complainant dated 18/3/2021. Where is your application? Page 18/3/21.
Or it is at page 42. Thereafter, there are 5
42. I am not on any other application, sir. Petition dated repeated petition
No,
dated
that-
are also pending for hearing with a prayer to change. Only prayer for change learned APP.
And the GRO also.
GRO also.
Kindly see the order. Kindly read further, madam.
That all the petitions are hereby rejected. For hearing Naraji petition filed with some date has been fixed, Naraji petition. You can have everything, you can have everything at the time of hearing Naraji. Naraji application.
Naraji is pending, madam.
Huh?
Naraji is pending. But my lord, kindly see.
Which documents were not produced? Which documents are kept hidden? Which documents are though recovered, not produced? You can raise all these questions at the time of hearing of the Naraji petition. Why are you saying the change of PP, change of GRO? Is it domain of the court?
My lord, according to the complainant.
Sir, you can do it administratively. Others forum where they are appointed by the government as well as GRO is.
The last part, my lord, for my satisfaction, considering that the APP attached to this court and the GRO are employees of different departments. In such situation, the court.
Absolutely right, sir. Absolutely right. APP is not under the judicial department, judiciary, High Court within the administration of High Court. He is not. He is under the judicial department. They are appointed by the judicial department.
That is true, my lord.
Then,
but CJM is the administrative head, my lord.
no, sir. Administrative head, he cannot transfer one APP, one court to another court. He has no jurisdiction. No, nothing. Inquiry is another thing, sir. Why you have filed this petition before the court? You can do it administratively. Otherwise, how can you file an application for change of PP, change of GRO? It is not within the domain of. I also work in the subordinate judiciary for.
I know.
Then there is no scope. This order, hard considered and rejected. This order is judicial order. If the order, instead of writing all these things, they are not department, they are not. If learned magistrate would write 3 words, hard considered rejected, that is right, absolutely right. After applying judicious mind, nothing to say about transfer of APP or GRO. I do not find any illegality or infirmity in the order to invoke the jurisdiction under section 482. Sir, I'm sorry.
But only because, my lord, yes, no.
Sir, you can raise all the questions, inaction, everything at the time of hearing of the Naraji application, which is pending.
Kindly,
Yes.
make an order, my lord.
Yes.
So that I can.
But I cannot say that transfer of APP and transfer of GRO can be taken up at the time of hearing Naraji application.
No.
That I can do.
Lordship will not
That I
mention
can
that,
do.
but considering the Naraji application on this.
Naraji application, you are at liberty to raise all the questions regarding
Regarding the merits of the case. my lord,
merits of the case. You can.
and regarding the perfunctory nature of investigation, well, that can be raised. in the Naraji.
Investigation. That is
can
right.
be raised, my lord.
Yes. Any investigation, any question regarding investigation, perfunctory, you can raise this at the time of hearing.
Since my lord, the APP was not cooperating, that is why one of these applications.
You have to deal with this matter.
Find the applications,
You have
sir,
to deal with this matter, not by the order of the court. Court can opine, but cannot pass any order of transfer. of ABP. This revision application has been filed challenging the order dated
Lordship and kindly record the file.
31st, yes, 31st March. 31st March.
Right.
Imprint order 31st March.
Yes, sir.
31st March
2021.
2021 in connection with GR case number 2687 of 2018, passed by learned Chief Judicial Magistrate HON'BLE, whereby learned magistrate disallowed the prayer for transfer of learned APP and GRO by filing application.
Well, file.
Prayer for by filing successive applications at the instance of defective complainant. Defective complainant, na? Defective complainant. Full stop. Learned forever. Learned advocate appearing on behalf of the petitioner / defective complainant has submitted that learned APP as well as GRO are not cooperating with the defective complainant in spite of perfunctory investigation and submission of charge sheet thereon. Was made in this case. Full stop. For a present. Learned advocate advocate appearing on behalf of the state supported the order contending entirely that this is the prayer before the learned Chief Judicial Magistrate was rightly dealt with, as there was no jurisdiction of learned magistrate to transfer either learned APP or GRO of the GRO concerned GRO concerned full stop for a person. Through your submission, I'm saying through your submission,
Yes. My lord, in this matter, my lord, regarding the my lord ingredients of 436, my lord, there is no such seizure list as well as the 161 statement of the witnesses, my lord. They also did not stated any.
that is to be considered at the time of hearing Naraji application, madam.
My lord.
Madam, I'm not on that.
My lord.
I'm on the legality
But this is
or
totally illegal.
informity. Illegality or
Another forum,
informity.
my lord, to agitate all these allegations, my lord.
This is not the forum. I'm in full
This is not the
agreement.
proper
Forever,
forum.
I'm in full agreement with learned advocate appearing on behalf of the state with regard to jurisdiction of the learned magistrate in dealing with transfer of learned APP or GRO. Full stop. Forever. In the aforesaid view of the matter, I do not find any illegality or informity with the in the order impugned. Full stop. Thus the instant revision application is liable to be set aside. However, is liable to be set aside. However, petitioner is at liberty to raise all the questions regarding investigation at the time of hearing Naraji application, which is pending before the learned Chief Judicial Magistrate. Poster with the opposite observation. This poster. Urgent copies, urgent for us to all connected applications যদি থাকে মনে হচ্ছে না আছে নেই
Regarding the agitated matter at the time of hearing of.
yes
Okay.
next who is state
As a motion.
motion stage hey which why it is not written motion oh motion stage chole yes yes what is your case
My case is the question of a proceeding initiated for alleged violation of certain provisions of respect of shops and establishments.
it's a
My lord, kindly come to page 34. 34 is the improved complaint letter.
34 hmm
My lord, kindly come to the next page. 34 is the narration of the persons who has lost his person and against him is not. So kindly see the next page, the 1, 2, 3 are the provisions mentioned. No details is attached to these provisions. These are basically the heads of the sections.
Case of the section, it was written against all the sections separately by not maintaining, that is 54(1) by not maintaining all the register and records.
Kindly see, by not maintaining all the registers and records in the 3 languages,
Namely,
by not maintaining all the register and records for the prescribed period, but prescribed period, but there has to some details regarding the period, has to have some material that except this minute, nothing is alleged against this person. But this is the first
question is that whether these by not maintaining all the register records, whether this will come within the purview of 54(1).
but subject to correction minute. If you not see 54, this section, this provision cannot go together with it.
By not having signature of employer in each entry in the registers. By not having signatures of all 54s go together, why not, sir? 54, section 54. Offense committed under section 54. Why not come?
Subject to correction minute. This is a.
Every offense he has to file separate complaint.
I'm not saying.
Then
My humble submission is, if the person does not maintain the register at all, then the question of
53, 43.
54 does not arise. Will it?
Yes.
Then the question of not maintaining the register in other languages does not arise. Will it? Because the primary offense according to them has not been coming.
Register. That is 54(1) is
54 has not been made out.
if there is no register under section 54(1), question of 54(2)(3) doesn't arise. Okay. Okay.
Now let me try it to page 33 for once.
30.
33, the just preceding page of the question have come to me. Well, let me kindly see the manner in which in this case cognizance has been taken. It's a pre-type order sheet. The learned magistrate did not apply its mind. Only the word of the offense under and the date is mentioned over here. Your lordship knows that this is not an accepted or mode of taking recognizance, and this honorable court repeatedly said, pronounced the orders that this is not an accepted and clear violation of Rule 83 of the criminal procedure, the criminal rules and orders.
Also, very true. কে আছে লোকটা খুব বসে পড়ে গেল এখান দিয়ে একটা ফুটো পড়ে হ্যাঁ তোমার হাতের সঙ্গে বেঁধে দেবে একটা সুতো আমি টানবো তুমি this revision application has been filed challenging the order date 1st March अच्छा in this challenging the proceedings initiated in a case number 1516 which magistrate chief judicial chief judicial magistrate is very Elizabeth chief judicial magistrate in connection with Baba, in connection with C case number 15165 of 2014 initiated by the learned chief judicial magistrate for the offence alleged under section 54(1), 54(2), 54(3) of the West Bengal Shops and Establishments Act 1963 and West Bengal Shops and Establishment Rule 1964. Whatever. Having heard, learned advocate appearing on behalf of the petitioner, as well as after perusal of the copy of the records, copy of the order initiating proceedings, or copy of the order initiating proceeding. The revision application stands admitted. Next para, learned advocate appearing on behalf of the petitioner is requested to start notice along with copy of the revision application upon the private opposite party number 2 through speed post as well as upon the state through office of the public prosecutor and to file evidence of service on the returnable date. This is the matter on as well. Considering the facts and circumstances, appearing in the revision application, let there be an order of stay of the proceeding pending before learned Chief Judicial Magistrate Alipur for a limited period, that is till last week of September. List the matter on second week of September. Second week of September. She posted it. Mongolbar 5/9 years. 5th September.
Item 12, 13, 14. Item 12, 13, 14 are analogous matter here. Case number and the violations are different.
Same.
On
12,
the case number and the
12, 13 and 14.
12, 13 and 14 on the case number and the violations are different.
Violation same.
No. different, but similar thing.
Group.
My lord, kindly page 30.
Yes, page 33. আচ্ছা, আগেরটাতে কি লিখলাম বলো তো? নিচের দিকে প্রথম তো হ্যাভিং হার্ট না, তার আগে না রিভিশন অ্যাপ্লিকেশন ফাইল কি হয়েছে? ঠিক 151 এই সমস্ত লিখছো না, মানে যা তা এই হইতো আগের রডটা দিন তো, আগের রেকর্ডটা দিন। আরে এই আমাকে 7টা অব্দি have to wait in my chamber till 7. দিন বাট কি বসাবে, তুমি দেখতেই পাবে না এটা কোথায় আছে। You will not be able to find out the খুব সমস্যা তোমাদের নিয়ে, না বুঝো না করো কিছু। 54(1), 54(2), 54(3 তুমি লিখে দিচ্ছ 154। Record will be placed before me without book. I will just put my signature. কোন দিকে থাকে, কিভাবে কি করছে? Yes, what is page you are referring to?
Page 33.
33. 33, next 35.
33 and 35.
This section 11. This section 11 রাখো, 54 এর জায়গা। Same order. Section 11, section 16. Read with rule 48. ঠিক আছে, ওই একই অ্যাক্ট। রেড উইথ 48 রুলটা বলার দরকার নেই, ওখানে যেটা আছে আমি রুল বলেছি, ওই একই রকম রুলটা লিখে দেবে। 64 বোধ আছে, একই রকম রুলটা লিখে দেবে, শুধু সেকশনের জায়গায় তুমি লিখবে 11, 16 and 18। ওখানে 54, 1, 2, 3, এখানে 11, 16 and 15, 8,
Subject to correction.
16, 11,
16 and rule 48.
rule 40, 11, 16 and rule 48 করে দিবে। ঠিক আছে, সেম। হ্যাঁ, এটাকে মুড়িয়ে দিলাম। 13 দিন 30।
And then 30, same direct, the violation is section 16 and rule 11 and rule 12.
Section 16, 11 and rule 11 and rule 12. Section is only 16. Same.
And we get the case number is C1564 of 2014.
Case number টা চেঞ্জ হবে। দাঁড়াও, আগেরটার কেস নাম্বারটা, আগের
And
কেস
the last one's case number is with C15162 of 2014.
2014।
2014. All are 2014.
এটা হলো, this one is, what is the cognizance order?
মানে cognizance order is at page 33.
Page 33। এটা হচ্ছে সেকশন হলো, সেকশন হচ্ছে under section
মানে section 60 read with rule 11 and rule 12.
60।
16 দিলেন 16
হ্যাঁ,
মানে
কোনটা দিলেন এটা, কোনটা দিলেন এটা? কোন রেকর্ডটা দিলেন?
Well, it's my mistake. It's my mistake.
14টা দেবেন।
Well, it's my mistake. It's my mistake. Well, the violation is.
হ্যাঁ
Well, it's my.
এটা ঠিক আছে রেকর্ডটা 14 তো
Sierra 226, correct? The case number is related C 15163 of 2014.
I have already stated, তাই তো? তো ভুল করলে পরে কে ভুল করছে আমি বুঝতে পারছি। এইটা আইটেম নাম্বার কত? 13 13 নিয়েছো নিয়েছো 13 এ
Well, that is.
তুমি আমাকে বলো না 13 13 এ কি লিখেছো? 13 section 13 section 11 section 11 section 16 section 16 and section 11 ঠিক আছে হ্যাঁ under the West Bengal Shops and Establishment Act, same as one. Read with West Bengal Shop Establishment Rule. একদম এক একটাতে যেটা বলেছি স্যার শুধু সেকশন গুলো আর কেস নাম্বারটা হচ্ছে 15162 of 2014 14টা দিন 14টা দিন আইটেম সেকশন এখানে 16 11 12 হ্যাঁ আর তারপরে একই করবে আর কেস নাম্বারটা হচ্ছে কেস নাম্বার ইজ কেস নাম্বারটা হচ্ছে 15164 of 2014 ঠিক আছে চলো শুধু সেকশন গুলো লিখবে
Item number 13, but the violations will be 14, reading section 17 and rules section 16, correct?
Sir, it is CRN number, please. 226 देखिए 226 देखिए दिन আমাকে দিন
Subject to correction by lordship.
এই অর্ডারের বাইরে তো আর
Well,
যাবো না
I can see page 35 for one split.
হ্যাঁ 40 52 17 হ্যাঁ না 40 17 আর 16 read with rule 52 read with rule 52 and 5 and 5 only 5 read with rule 52 and 5 প্রথমে লিখবে সেকশন না রুল 40 দাঁড়াও এটা কেটে দাও সেকশন 17 section 16/17 read with rule 52 40 52 and 5 কেস নাম্বার বলে দিচ্ছি আমি 15162 14 এটা হচ্ছে আইটেম নাম্বার 30 yes কমিউনিকেশন বলে ঠিক আছে দেখো this proceedings yes next Your state, not this week. Huh? Why not tomorrow? Why not tomorrow? Why not tomorrow, sir? You have come only for adjournment. Get yourself prepared on the next date. You will argue the matter. You will make submission. I not this week, but next. Hmm.
আমরা স্টেটে আছি তুমি কোথায়
Who is on behalf of the state?
I am from the state lord.
State.
The last one.
List me. अच्छा अच्छा ठीक है Every service filed where the petition is taken out of both the land adverse for the parties to the present case diary has not been produced land adverse for which the appearance may be last week of August until further. Speak up, sir. Where is your city, sir?
My lord, one time, my lord. I have sent message, but I have not received message. Next Thursday, Mercy Button.
Next Thursday.
Yes, Lord.
Which police station? Bushirat. Either he produce the case diary or I will ask SP to appear before this
Yes, my
court,
lord.
sir. On the next day.
Next date, Lordship. We
Take
have
it
not
from-
misplaced the
Take it for
bill,
granted.
my lord.
I will pass an order directing SP to appear before this court.
Yes, Lordship.
Otherwise,
My lord. this
learned
matter is
advocate
Lordship.
appearing on behalf of the state has submitted that city case diary has not been produced before it. The last opportunity is being given to the officer in charge of Bosirat Police Station to ensure production of the case diary before this court on the returnable date. Otherwise, consequential order shall follow. Next. Release the matter on 3rd August. Sir, 3rd August fixed.
Yes, ma'am.
Yes, ma'am. Third August.
Nothing further. Next.
আজকে দিয়ে দিস আজকে দিয়ে দে
22 minor land.
Then record. You are on behalf of the petitioner. Watching. Item number?
26.
Yes, sir.
Lordship, the petitioners before your lordship
Ah.
are officers of Eastern Coalfields.
Ah.
My lord is aware, Eastern Coalfields Limited is 100%
public sector undertaking owned by the center. My lord, I have on an earlier occasion, before your lordships, a compendium, my lord, they just
Yes.
addressed to your lordships. My lord, we'll see in that compendium, there is a synopsis where, my lord, all these officers of Eastern Coalfields Limited by the, my lord, if lordship kindly comes to the index page, it is the second page of that compendium. My lord would see by 1, 2, 3. It's first 2, point number 2, and then 3. My lord,
Page 2.
Page 2. Page 2 is the index.
Index, yes.
My lord, in the index, what I wish to show to your lordship is that these officers are also public servants notified under the Gazette notification and amendments. Well, I have provided the ISO numbers. 3, those are annexed to the
Gazette notification amendment, SO number 1858.
yes, 1856, 645, and my lord, in respect of Eastern Coalfields Limited properties. The my lord, my lord, briefly I will just summarize for the lordship. My lord, lordship is aware, we are all aware that in that bed, Uriari bed, what is happening in the state of West Bengal? There is complete nature of a parallel administration running of these persons who are involved in the illegal trade or illegal mining of coal. And only the Eastern Coalfields Limited, as the custodian on behalf of the government, has been fighting this fight.
Has been fighting.
Fighting this fight with them to protect the coal of the country. Now, series of, and they retell with series of cases against officers whenever there is an action, with police help under intervention of this honorable. Police help, police state, but they go, they remove the evict from the public premises, not the Public Premises Eviction Act will apply. They remove those illegal coal miners or smugglers, or it is a huge coal field. In that coal field area, wherever there are squatters found, these persons were the trespassers. They created a ruckus. When this eviction right was going on, they created a ruckus. They prevented the public servants from discharging their due. 353 IPC offence is made out. A case under section 353 and other provisions are started. First FIR at the behest of PC. As a counter plus from one of these persons who are an accused and his wife.
Who is an accused of your case?
Yes.
Yes.
He lodges a FIR.
What is your FIR?
These persons.
What is your FIR? Page?
My FIR is at page 22.
Page?
22.
22.
22.
This is your FIR.
Yes, my ECL document. Type C.
Yes.
Type C, the joint rate. It is starts. I'm reading from page 23, Mother.
23 is the complaint.
Type C is the first line itself. Joint raid was conducted by ECL Security Department, CIS, and police. Police means the police of this particular police station, where at Dabar Colliery, the mines were filled with miscreants. The raid party perused the miscreants who had escaped from the area This would be
Hmm.
pursued.
Hmm.
As the raid party reached the double colliery and observed that there were many illegal miners carrying out illegal mining inside the mines, miscreants and thieves inside the mines. They were stealing coal and were stashing the same coal. As soon as they saw the raid party, they started to escape. At Radhavallabhpur, Kalipur site and inside an abandoned state building, approx 14 metric ton of illegal coal, unverified, along with 5 coal-laden cycles were seized. I looked around the abandoned house and found one Radhesham Singh, son of such and such. My lord, kindly notes the second name, Srimati Nivam Devi.
Hmm. Hmm.
This is the opposite. This is the complainant of the case in which I am seeking prosecution. The counter last case, Srimati Nivam Devi. Others are habitual coal racketeers collected the same coal illegally and staged there with a view to transport the same elsewhere for wrongful gain and cause wrongful loss to national property. A total 14 metric ton of coal was seized. This seizure was done by the police. The miscreants assaulted the raid party with sharp knives. Kindly note, my lord. Miscreants assaulted the raid party with sharp knives and instruments, and it is also learned that these miscreants, Radhesham Singh and Nigam Devi, Sabir Ali, there are 3 accused names, and others, along with help of illegal miners, have been running clandestine coal business since long. Accordingly, I seized state 6 metric tons clean coal at Alamat under proper seizure list and all seized coal on Simma under proper Simma. Then, in page 24.
Accordingly, I seized. Who seized?
Mr. Manoj R. Langade. My lord, I have pointed out
Of
of ECL, area security officer. They are public servants within the meaning of section 190, section 21.
seized the same stage. Yes.
As Alamat under proper seizure list and to call seized coal on Sigma. Sigma was handed over
To call
under proper Sigma. These people have also resorted to instigating the villagers against the raid party, resorted to unlawful assembly, and has put themselves in front of payloader. Payloader is the machine which extracts the 14 metric ton coal to be taken to stop the public servants from seizing the coal. They had abused and also assaulted the raid party, in which it became a law and order situation. They also threatened to give false rape and molestation case. Malad, kindly see. False rape and molestation case, that's misusing the law of the land. This complaint is lodged and my lord, a case is registered in FIR number 28 of 2016. At page 22, my lord,
It was lost on when?
on 31st January 2016.
31st January 2016. Yes.
This is the thread. Now, my lord, lordship will find the counter was
Where is there?
57.
There?
Page 57. 57.
57. 57 is there.
And the thread which is stated in FIR number 28 is executed in FIR number 29. The same Nigam Devi. The same name.
Please wait. Nigam Devi.
Nigam Devi. Nigam Devi is the name that you see. FIR number 20. 3 files, FIR number 29.
File.
Can you please?
Wait. Please. First. On when it was 30.
1st January 2016.
Same date.
Same date at 35 hours.
31st January 2016.
Our complaint was at 10:25 hours, when at 10:25 AM.
It was 13:35 hours.
Her complaint was at 1:35 PM.
Huh?
13:35 to 1:35 PM.
13:35 hours.
Our complaint is at 10:25 hours. The
Here
ECL complaint, page 20.
it is your matter. Your complaint on 31st 1/16
at 10:25 hours.
at 10:25 hours.
My lord, column number 3, my lord, please. Column number 3.
Column number 3 of
General diary reference 1542 at 10:25 hours.
GD number 1549. It is 1549.
My lord, 1549 is third one.
Hmm.
It is at 3035. At page 22, my lord, please see.
It was 1542.
And at 1025 hours. At
10:20.
1020.
Yes.
My lord, lordship would be shocked to see. My lord, I take your lordship now. My lord, this eviction right and the seizure of the coal took place under order of this honorable court. My lord, will kindly see from page 26 onwards. For once. These are all unimpeachable orders of this honorable court, which were the petitioners before your lordship were discharging the duty or their solemn duty of executing your lordship's orders passed in division. My lord, kindly please. Second paragraph of page 26. We direct the Coal India Limited and Eastern Coalfields Limited to ascertain if there is any person who is in occupation of any quarter or related to any employee is not entitled to any allotment of quarter. Market rate shall be assessed. Realized from occupants those who are instigating, helping, aiding them to remain in occupation, of course, till they are evicted. Those persons who are instigating and helping and aiding either directly or indirectly will be free to approach. My lord, I am not going into this. Kindly see page 27, last paragraph. We restrain all the persons concerned except officials of coal mines, Eastern Coalfields Limited. We are granted that authority. Police authorities as well as government officials from preventing or interfering with the lawful action so to be taken might be taken by the officials of coal mines and police authorities. My lord, then kindly see, if any obstruction is put forward by any person, either directly or indirectly, police assistance shall be provided. Page 27, last paragraph. The cost so to be incurred by police assistance shall be assessed and realized from those persons who shall be instrumental in putting resistance as public demand by the public authority, by the police authority. In addition thereto, appropriate criminal proceedings shall be initiated by the concerned commissioner of police for preventing and or obstructing the public servants in discharging the duty as an offence under the appropriate laws. This is direction by this honorable court, my lord, in division. Kindly, my lord, then see page 38.
38
16, yes, page 38.
starts from 37.
Yes, it starts from page 37. My lord, here I want to show to your lordship, kindly see the ECL authorities were granted, the authority of were directed to demolish all quarters which have been created in the ECL land. Page 38, the learned second paragraph. The learned additional Solicitor General has been kind enough to apprise this court of the steps taken by the authorities in dealing with the issues raised in the petition, particularly in respect of unauthorized occupation of quarters, eviction of occupants within the control of the Eastern Coalfields. He has also submitted unauthorized electric connections, water connections are now being disconnected with the assistance of the local police as well as the CISF. Has placed before us a chart reflecting the number of quarters unauthorizedly occupied, number of eviction notice issued, number of eviction order passed, number of quarters vacated, number of quarters demolished, number of prayers submitted, etc. Understand? Times the order imposed. Page 40. Page 40, last paragraph of page 40. The learned additional government leader assures the court that the state police, this is an assurance before the court, the same police which has registered the FIR. The learned additional government leader assures the court that the state police would continue to extend cooperation and has tendered the report of the superintendent of police, where it is stated the police has rendered police assistance to Coal India Limited and its subsidiaries, particularly Eastern Coalfields Limited. So also to the West Bengal State Distribution Board to curb the unauthorized water electricity supply, and that the police personnel in the district are performing its duties as and when any assistance is sought. It has taken prompt action in the matter. We record our appreciation for the steps taken. My lord, then kindly see page the next order starts from page 47 and the relevant portion is at page 49. That is the order in page.
47.
47 it starts from. Rather, Malad, I would just read first so that I will read this order in its entirety so that the ground reality can be shown to your lordship. It is brought to our page 47.
Sir, first you say the date of the order, first order.
The date of the first order was from 5th October 2012.
5th October. 5th October 2012. When the second FIR, that is challenge before this court, challenge in this revision application. Challenge.
Fictional application is FIR number 29.
Date.
Dated 31st January 2016.
16.
Malad, here page 47, Malad, you see.
Yes.
It is brought to our notice by the learned counsel. Malad, here this is like a continuing mandamus under the public interest litigation jurisdiction, where time to time the matter comes up, status reports are filed, and Malad will be shocked to know that only 10 to 20% because of local political interference and other things, only 10 to 20% of the portion of the ECL area they have been successfully able to write them out or to seize the pool. But it is rampant.
Only 16.
In the newspaper,
Only 16. You.
From till date 23 years. It is called. It is brought to our notice by the learned counsel appearing for the respondent ECL that persons who are in illegal and authorized occupants of quarters as well as those squatting on the land belonging to ECL are also enjoying unauthorized electricity, water, etc. It is submitted that unless illegal and unauthorized electric water supply is terminated, trespassers and unauthorized occupants would continue to occupy. Kindly the submission of the learned ASG. The learned ASG also informs that the court that this is one of the main reasons that rank trespassers, encroachers cannot be removed from the estate of ECL. We therefore direct authorities to take immediate steps to disconnect, withdraw electric water supply to persons who have encroached, trespassed the properties of ECL by undertaking a massive exercise and further take preventive steps so that illegal electric water connections are not accessible to these unauthorized occupants and trespassers. Needless to say, authorities would follow due process by taking action in the matter against unauthorized occupants, trespassers, including water. The learned counsel for ECL submitted superintendent officers that they will extend all cooperation. Kindly then see page 49. The authorities, in order to implement our order, may seek police protection. Kindly see page 49. The authorities, in order to implement our order, may seek police protection, and in case such a request is made, the superintendent of police Burdwan, as well as other police officers of division jurisdiction, the estate of the ECL is situated, would provide sufficient force to the authorities for implementation and execution of our orders. This is the order passed by this honorable court, and thereafter this drive has been continuing from time to time. Time is page 50. It starts from page 52. The next order. Time is page 53. These are all in relation to this. Then the second paragraph, the third paragraph, page 50, last paragraph. Let the state and its authorities. This is also by a division. Take appropriate action so as to ensure that no unlawful and or unauthorized mining is done, and unauthorized and or unlawful selling of the coal in Durgapur, Asansol, Raniganj, Koliyari is not made in any manner whatsoever. Let the state government constitute a special cell of the responsible officer to ensure the compliance of the order and appropriate action be taken to check illegal mining and selling of the coal. Within a period of 4 weeks from today, action taken report is submitted before this court after 6 weeks. Now, my lord sees, I'm coming back to our the case which we had lodged.
Hmm.
Coming back to the case which we had lodged.
Yes.
Under the drive order of this eviction drive and recovery of digital court drive,
Hmm.
police was with us.
Police?
Police party was with us of the same police station. They were the Salanpur police station officer in charge and others were admittedly there with us. It was a joint raid of ECL, Central Industrial Security Force and police person. A attack on public servants made. They were somehow protected by police interference only. They only protected us because they have the amenity. Who are the ECL officers? They are regular executives who have no condition to protect themselves against an attack, physical attack. That's what resisted by the police themselves. At 10:25, this FIR is lodged by them. And Lordship can very well understand there was local level interference at 3:35, 1:35 p.m. That counterblast case is lodged, implicating all these officers of PCL. If my lord, if kindly,
Who are the petitioners in this case? Who are the petitioners?
all the my lord, here I kindly comes to the first item.
1, 2, 3, 4.
1, 2, 3, 4. My lord, I have shown the designations at page paragraph 1 of the
Designation.
petition. The petitioners number 1, 2, 3 are officers of Eastern Coalfields Limited, presently posted as area security officer.
Eastern Zone presently posted as area security officer, security sub-inspector,
assistant
security
security sub-inspector,
sub-inspector of the Eastern Coalfields Limited.
and petitioner number 4, my lord, in the next paragraph is a security havildar of Eastern Coalfields
Eastern
Limited, also operating in that.
Yes.
The same police party which is present is my lord, lordship already aware, and I will just briefly show to your lordship. My lord, in a case of almost similar nature, where the Honorable Supreme Court came to a, there was a case under 498.
498?
I'm drawing a parallel with another case.
498A.
By a lady, filed by a lady. But what happened when the police went with lordship knows how executions are, the search and seizure is made under 406. From lady's family, lady's brother was present and police personnel went for search and seizure of the Steeron articles. When they went to search and seizure of the Steeron articles, the father-in-law lodged a complaint that gold ornament has been
Stolen away.
stolen. While this raid was going on, the Honorable Supreme Court came to a conclusion that if you have to implicate, since the police is the same police station, if you have to implicate the person that he picked up the brother-in-law, that is the daughter-in-law's brother who was present, he picked up, he simply lodged an FIR against him, discounting the police. Supreme Court said that it is absurd. If the police were present, you have to also implicate the police. That they were in the raiding party. At a raiding party, together goes for a raid, and you implicate them. This absolute malafide, absolute counterblast. Lordship, I am placing this for your lordship's time consideration. 673. I will just briefly summarize from the top at the lordship will find the summary of the facts in the head note, then I am coming to the paragraph. Allegation of theft. First head. Allegation of theft of bangles by appellant, brother of daughter-in-law of respondent number 1, during raid by police at respondent number 1's house. Respondent number 1 arrested on complaint of his daughter-in-law. It is absurd to think that appellant who was present with police party would venture to pocket the bangles in their presence. Then on the point of paragraph 10 to 12, this is reflected from paragraph 10 to 12, where Bhajanlal.
What is the time of alleged commission of offence according to FIR lost by the said lady
By the same lady.
in your case? What is the time?
135.
135.
135 is the time of.
No, time of lodging, not lodging FIR. I'm talking about the incident happening.
Incident. This is page 58.
58. 58. Yes, 58. That is.
আপনাকে জানাইতেছি যে অদ্য 31/1/2016 রাত্রে আনুমানিক 1টার সময়
Yes.
31/1/2016 1টার সময়
Yes.
রাত্রির 1টার সময় মানে একটা ওয়ান পার্টেন started word only something has happened at 1 a.m. in the night and she is waiting till the complaint is lodged by the ECL against her husband, not only she, her husband and all the illegal minors at 10:25 and she lodges a complaint at BIBHAS after this complaint.
Yes.
Rank benefit, ECL officers are being, when my lord ECL officers are executing your lordship's order, seeking cheating in PIL jurisdiction, they are being prosecuted, they are persecuted like this. My lord is already, I am not thinking that my lord is already aware of the, I have shown this judgment before because of the similarity of facts, the Supreme Court judgment, where my lord is aware of HON'BLE clause 7 and clause 3. Clause 7 says where the criminal proceeding is manifestly attended with maleficence and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused with a view to spite due to private and personal grudge. That is one of the grounds. Second, my lord, where the uncontroverted allegations made in the FIR or the complaint and the evidence collected in support of the same do not disclose the commission of any offense and the allegations are fatally absurd and inherently wrong. What is most disturbing is the same police station which was a party to the joint raid has registered this first information. And they, needless to mention, they have been, if there was any incident, they have been discovered. If there was a skirmish, it was between the police and these people. So if there was any, I will say that it was a dereliction, then how can we be singled out? Say we are being protected by a shield where lathi charge or anything is going on in execution when there is a skirmish going on. But the ECL officers are picked up and separately prosecuted. Apart from Manoj Mahavir Prasad, there are other judgments on the point of maleficence and counterclass. Each case has its own facts, but one of the jurisprudence is clear pertaining to that where lordships find something to be palpably counterclass, something which is so palpable, so explicit that maleficence can be at this stage and under section 482 lordships could be exercising lordships powers under section 482 and using clause 7 of HON'BLE. Kindly sees the case of 2015 volume 11 SCC page 730. BP Bullard. This was also a case of counterclass. Here what happened? A check was bounced. Check bounced. 138 proceeding was initiated. Like similarly, Ravi had initiated. Yes. And in retaliation to that, the accused in the 138 case started a proceeding of forgery, stating that this particular check was forged. Very easy to say. Paragraph 7 to 10, where the other celebrated judgment of the Honorable Supreme Court, Rajiv Thapar, has been relied upon by the Honorable Supreme Court, and it has been held after referring to Rajiv Thapar and Rishipal Singh's case. Those are basically relied upon in paragraph 7 and 8. Kindly see paragraph 9.
Yes.
In view of the above position of law and having regard to the facts and circumstances of the case after going through the criminal complaint and thereafter one filed by him against the appellant, we are of the view it is a clear case of abuse of process of law. a case which is started as a counter blast.
Hmm.
To a complaint under section 138 was quashed by the Honorable Supreme Court of India. Then, my lord, Lordship is already aware of these two judgments. But here, even in cases pertaining to section 376 of the Indian Penal Code, where a lady files a complaint, lodges an FIR, stating that she was ravished. Even in those cases, Lordship is aware of Vineet Kumar and Ahmed Ali Qureshi. Both of these cases are. Even in the case of 376, the Honorable Supreme Court has exercised jurisdiction on malafide, stating, in Vineet Kumar's case, what happened, there were monetary transactions between the parties.
Hmm.
Monetary transactions, there was kindly see paragraph 38 on it.
Thirty-eight.
38.
Hmm.
There was sufficient material on record to indicate that there were financial transactions between the accused and complainant, her husband and son, on dishonor of checks issued by the complainant's husband and son. Proceeding under 138 of the Negotiating Instruments Act were already initiated by the accused. All family members of the complainant were living in the same house. The brother of the complainant's husband and his wife in statements before the IO have admitted monetary transactions of his brother with the accused. The statements before IO of both Nikesh and such have already been extracted above, which were part of the case study, was material which ought to have been looked into, which was submitted by the IO in the final report. Then, my lord, kindly sees the Honorable Supreme Court has had page about paragraph 40. The Honorable Supreme Court has relied upon the case of Prashant Bharat discussed on facts.
Hmm.
There, my lord, in paragraph 39 of this judgment, there was a 164 statement. Even a 164 statement was there by the link. At the last line, what you will find.
Yes, yes.
Paragraph 30.
Yes.
We are conscious that the statement given by the prosecutrix complainant under section 164 CRPC is not to be lightly brushed away, but the statement was required to be considered along with the antecedents, facts, circumstances as noted above.
Yeah.
And then, my lord, at paragraph 41, inherent power given to the High Court under section 482 CRPC is the purpose and object of advancement of justice. 41, 41.
Hmm.
In case solemn process of court is sought to be abused by a person with oblique motive, the court has to be thought the attempt at very threshold. Court cannot permit the prosecutor to go on if the case falls in one of the categories as illustratively enumerated by this court in state of Haryana versus HON'BLE. Judicial process is a solemn proceeding which cannot be allowed to be converted into an instrument of oppression or harassment. When there are materials to indicate that a criminal proceeding is manifestly attended with malafide and proceeding is maliciously instituted with an ulterior motive, the High Court will not hesitate in exercise of its jurisdiction under section 482 of the Code of Procedure to quash the proceeding under category 7. But this was a case, most shockingly, in this case, 138 Devotional Instruments Act was started, and the lady of the house was used to retaliate with the case under section 376, saying that I is judge. Malad, I beseech your lordship's kind intervention in this case. I seek protection of your lordship. Malad, this sort of case, Malad, has far-reaching consequences and would deter public servants from discharging their duties. And there is also a presumption, lordship is aware, that public servants have a presumption in their favor that they discharge their duties in good faith. Subject to what?
Well, in fact, lordship, I have only FIR, lordship.
FIR of your
Only a
case.
copy of the FIR.
Copy of the FIR of your case.
Yes. lordship.
Only. CD statement of any witnesses there? No.
Well, I do not. CD is not with me, no.
CD is not with you.
Then, in fact, lordship is desired to see the case study. Fact is that public official went to the raid thereafter this case is filed. It is admitted by
That also under the
Under the order of
supervision of the
Honorable
Honorable
High Court.
Court.
Yes, Lordship, it is admitted.
They were directed along with
Yes.
CISF, the standing
Person who
security
went
force
to
of
the-
the industrial
Yes,
area.
yes.
Along with CISF, local
Yes,
police,
yes.
they also raided.
It cannot
After
be
raid, they
Lordship.
had been to PS and filed it.
If Lordship desire, otherwise
I
may
have
be
to-
disposed of. Lordship.
I have to, I'm reserving this
Yes,
judgment. I'll have to write it
Yes,
very
Lordship.
thoroughly.
Public officer is harassed by the.
Yes,
Yes, Lordship.
I'm keeping your compendium also. Keeping your compendium.
Yes.
এইটা এই খেসলাগুলো খুব সাবধানে, এগুলো আমার লাগবে খুব। আর এইখানে যেটা এই যে ফুটাগুলো একটা যেন না নামে, বুঝছো? দিস ফ্ল্যাগ গুলো একটা যেন না নামে, এখানেই আমার আগেও ছিল, ওই 15টার মধ্যেই পড়েছে, খুলে না যায়।
ঠিক
নেক্সট হুম দেখুন নেক্সট দেখুন পরটা। Then is there next? You are on behalf of the state. 23.
Which matter? 23.
দেখুন দেখুন তারপর দেখুন
Vidyut Rai is appearing. It is
23. Okay.
23.
দেখুন দেখুন পরটা দেখুন।
24